So the last video we were talking about the role of the jury in sentencing, and then what the judge has the discretion to do. Defendants sentenced to incarceration will either go to county jail if their sentence is less than 1 year, and many years state or federal prison for more serious crimes, or sentences that are more than a year, or they may be placed on probation. There could be a combination of penalties, a combination of incarceration and probation, a combination of probation, community service. So there's different types also of probation as to where you can or can't go. Are you under house arrest? Are you when you come and go to jobs? So there's lots of different options that are available. There's also diversion is also an alternative. If a particular defendant is charged with a particular offense, and the individual meets those requirements for diversion, then they can be assigned diversion, meaning that there's some requirements that they have to meet, whether it be community service or probation or getting a job, whatever, going to drug treatment. And as long as the defendant fulfills those requirements, then they complete the diversion and the case will be dismissed. If they fail to complete those requirements of the diversion, then they're going to be prosecuted for that crime. The objective of diversion is to defer the defendant from further wrongdoing by giving them an incentive, a way to avoid a criminal record. This is good for first-time offenders, for not necessarily violent crimes. Lots of times it's used in drug cases, hoping that the defendant will go to go through a treatment plan, and thus get their life on track. Most defendants who are eligible for diversion will choose that option at the arraignment or soon thereafter, and thus they don't ever go through the trial process. The last thing we want to talk about is appeal. If the defendant, is convicted of a crime, they have a right to appeal. A very high percentage of convictions that result in prison sentences are appealed, and about 10% of those are reversed on appeal. Very rarely are lesser sentences appealed, just because you will be out of prison before the appeal could ever be heard. The most common reason for reversal on appeal is that the trial court improperly handled evidence or admitted improperly obtained evidence that fell short of a constitutional requirement. If that conviction is overturned on appeal, then the defendant cannot be tried again. Most times may or may not be tried again, and it really depends on what was the reason for the reversal if it was reversed due to improperly admitted evidence and that evidence is disregarded, then there may not be anything remaining to support the charge. Sometimes it can be reversed with or without prejudice, meaning the prosecution may be barred or may not be barred from retrying the case. So, like I said, this is a very, very, very brief introduction into criminal law. You will get a lot more clarification, a lot more detail, and a lot more in-depth study in the criminal law class. Thanks so much, guys. I've enjoyed this semester, and I look forward to seeing you guys in legal research and writing. Thanks.